right, welcome everyone to Understanding the Clean Water Act and Ag, Biosolids and Food Processing Wasteland Application. My name is Audry Thompson, and I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. I'll go ahead and get started while Brook pulls up his PowerPoint. The Understanding Agricultural Law educational series is a course designed to develop subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not specialize in agricultural law. This series is sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, a new initiative spanning the Bureau of Market Development's Economic Development Division, established through the 2019 Pennsylvania Farm Bill. Next slide, please. Designed to enhance the long-term vitality of Pennsylvania farms. That is. Yeah, the ABDC is focused on providing support for sound business planning, efficient transitions of farm ownership, strategic farm expansion, diversification of agricultural production, and in building a team of financial and technical expertise as a resource for Pennsylvania farmers. The ABD supports farm transitions, linking farmers to the next phase of their life and their farm's future, beginning farmers, providing advice and counsel to the next generation of Pennsylvania producers, risk management, providing information on crop insurance and other risk management options, and financial assistance, connecting farmers with low-interest loan options and reimbursable grant programs. To meet the challenges of the 21st century agriculture, ABDC will help grow opportunities and resources, remove barriers to entry, and cultivate and nurture future generations to maintain the sustainability of Pennsylvania's premier industry. Next slide, please. Including today's webinar, we've presented 45 programs in the Understanding Agricultural Law series, including programs on ag labor, finance, Pennsylvania's Clean and Green, and many, many more. You can find materials and recordings from all of those programs on our landing page for Understanding Ag Law at our website, aglaw.psu.edu. That's there in the chat as well. Additionally, as you can see here, this is the third program on the Clean Water Act and Ag. Links to those programs, along with all of their materials and recordings, are linked on this event webpage. Next slide, please. Go ahead and put some more things in the chat here. And we encourage you to mark your calendars and register for our upcoming programs. Under this series, Understanding Ag Law, we've got Pennsylvania's Seasonal Farm Labor Law on January 23rd, USDA's National Appeals Division with guest presenter and former USDA Administrative Judge Devin Winkowski. I did not put that on the slide, but we will have a former USDA admin judge presenting that program there. Right to Farm Laws on March 27th, Renewable Fuel Standard on April 24th, the PA Preferred Program on May 22nd, Ag Vehicle Regulation on June 26th, and International Agricultural Trade and Tariffs on July 24th. Those are all at noon on Eastern Time, and Pennsylvania Attorney CLE is available for each program. You can register from the Understanding Ag Law landing page or our events page on our website. Next slide, please. We've also got our quarterly dairy legal webinar, and our next webinar under that series will be Tuesday, January 27th, covering the fourth quarter of 2025. We're going to talk about standards of identity for dairy, regulations, and current issues. We also have additional programming scheduled in April, July, and October, as you can see there. Those are all noon Eastern Time, and PA Attorney CLE will be available for those programs as well. And next slide. Perfect. We are also excited to announce that we've teamed up with Penn State Extension to offer education and services through the AgWorks program, which is funded 100% with federal funds from a U.S. Department of Labor grant totaling $1.3 million and 0% non-federal funds. This two-year program aims to link agribusinesses to workforce services, educate workforce professionals about the needs of agribusiness, provide services and training to individual agribusinesses based on needs, help small agribusinesses grow and succeed, and the program will also register 1,000 agribusinesses in the PA Career Link online system. Under this program, the Center for Agricultural and Shale Law will present 20-plus employment law programs geared for non-attorney producers and business owners and provide legal consulting for program participants. Upcoming in that series, we have anti-discrimination law compliance on December 16th, wage and hour laws, requirements and exemptions on January 21st, and then wage and hour laws, calculation and enforcement on February 24th. Registration is available for that on our events page and through Penn State Extension. So if you're watching this webinar and you know a PA farm that could benefit from this program, or maybe you are a PA producer who could benefit from this program, please visit the website and share the contact information, take and share the survey, and register for the upcoming webinars, and refer ag businesses or questions to agworks@psu.edu. Next slide, please. And finally, just a few reminders before I turn this webinar over. This webinar is being recorded. If you have any questions, please write them in the Q&A feature and I will collect them and ask them at the end. We'll encourage you to fill out the poll at the end of the webinar. Tell us what you like, where we can improve, and what topics you would like to see in the future. And if you are interested in CLEs, there is a CLE form linked on the materials page for this event here. You need to fill out that form to get your credits for the CLE. You must be registered for this webinar to receive CLE credit. So if you're watching this webinar with a friend, please register independently so that we have your registration confirmation information as well. And as part of our responsibility to ensure attendance, we will provide a code word later in the program that you must enter into the form. And if you have any questions about any of this, you can contact us at aglaw.psu.edu. All right, I will now turn this webinar over to Brook Duer, the Center's Senior Staff Attorney and former Chief Counsel of Pennsylvania Department of Agriculture, who will be retiring at the end of this month. We wish him all the best and a happy and fulfilling retirement with his family. So, for one last time, Brook, the screen's all yours for understanding the Clean Water Act and Ag, biosolids and food processing, wasteland application.
Okay, thanks, Audrey. It's been a pleasure working with you and Jackie, who's on with us. And I see we have a real packed house here. We got 99 participants in this event, which is just great. All right, now the title of this is Clean Water Act, so that it fits with the other two that we did, and then the actual focus topic, so to speak, is biosolids and food processing waste land application. Now, I have to apologize right away by saying I should have called this Clean Water and Ag, which is the way I've amended this particular page, because as I was preparing, it was all of a sudden the light shine, came on over my head, and I realized that most of what we're really going to be talking about is probably the Clean Streams Law requirements of Pennsylvania, or let's put it this way, the Biosolid land application permitting process is more a product of the Clean Streams Law than the Clean Water Act. But it's important to understand the way that these permits work and everything by understanding what the Clean Water Act does versus where the state's jurisdiction comes in. And of course, we have this overlap where, and I've talked about this in the prior ones, where this state is doing the work for the feds with regard to sort of frontline Clean Water Act compliance in many occasions. So anyway, for those of you who are sharp and can see that little inconsistency, this should probably be called Clean Water and Ag. Okay, now these were our two before, and there's my little notation in the bottom about my amendment to the title, so to speak. Now the agenda will be, again, I will do a short Clean Water Act recap just to bring you into the sort of the thought processes. And then we'll talk about biosolids land application in PA. And as I've noted with the asterisk, this is in accordance with federal Clean Water Act and PA Clean Streams laws or Clean Streams Law requirements and regulations. So, and I apologize because I don't have a lot of slide pages that are directly sort of laying the foundation for, under the Clean Streams Law, although I, of course, have all the regs well covered. So, let's go forward again. Okay, I didn't even touch the thing that time. Okay, and then we'll do food processing residual waste land application in PA. Two terms, food processing waste. FPW is what some sort of references or terminology that's used. Food processing residuals, FPRs, seem to be the more common way that people are referring to this. It's all residual waste under the Solid Waste Management Act. So call it what you like, food processing residuals, food processing waste, food processing residual waste. FPRs is kind of the way it ends up getting, for convenience sake, getting referred to. So we'll just probably fall into that pattern. And then we'll talk, after we cover those basics, then we'll cover the top topics, which is why we're here, why this is even a webinar, which is that we're presenting, is that this issue of PFAS in biosolids has exploded, to the sort of to the forefront, as well as, and it's little calmer now than it had been a while ago, but not that the need isn't there, which is problems with Pennsylvania's FPR regulatory scheme. And the Pennsylvania General Assembly, of course, is all over that. There have been a number of bills. There is one that it's still pending and will carry over in January when they come back. We will have more activity, hopefully soon, on the FPR legislation. Now, I am not going to talk about that because we got enough to cover as it is, and who knows how that's all going to turn out. So I don't like to talk about things that aren't law yet. Well, put it this way. I don't like to, generally talk about them, particularly in something like this, which we want people to watch in the future. And I don't want to be talking about something that may never happen. Okay. Now, Clean Water Act history again, came into being in 1972, and then there was amendments up to 77, and that's when the word Clean Water Act finally, came into being. And then prior to that, of course, the last bullet point's important to know, which is the old statute was only dealing with ambient water quality standards. And it's specifying an acceptable level of pollutants, pollution in a particular, interstate navigable water. And that was not very effective as pollutants, and let's put it this way, as the source of pollutants became the focus, then, the entire process changed, or the objectives changed to two major objectives of the Clean Water Act: regulate discharge of pollutants into waters of the United States. Okay, remember that's waters of the United States, and then number two, regulate water quality of surface waters, which means other waters too. And for example, if you just look at it this way, number one is all about sort of the MPDES permitting system, and reaching out and identifying specific contributors who are making discharges, whereas regulating water quality standards is more like the Chesapeake Bay problems, which is a general water quality effort with regard to a particular body of water. And of course, we don't want to get into the whole waters of the United States thing and the navigable waters thing. That's for hours and hours of other discussion. Okay. Now, interestingly, the definition of pollutant in the Clean Water Act includes sewage sludge, and also includes industrial, municipal, and agricultural waste, which could theoretically be, food processing waste. So, to some degree, in one way or another, they're both the substances we're here to talk about are considered pollutants under the Clean Water Act, or can be. Let's put it this way. And then here's the definition of discharge, because again, the federal law is all about point source discharges. I think I have a slide here coming up. Yeah, here we go. Is all about point source discharges, as opposed to diffuse, or let me say that again, diffuse discharges, non-point source discharges, which is much more what we would have resulting from the land application of either of these two. The only reason CAFO permits get into kind of a point source issue is because the idea is that the federal government has defined a CAFO as, if it's has enough animal units to meet the definition, it's kind of becoming a de facto point source, and it's being treated like one, even though it is the mechanism, of contribution to water quality or degradation of water quality, is really a form of diffuse discharge. All right, next slide. Okay, so there's this whole issue with the state administration of the Clean Water Act and this, on behalf of the feds. And I'll tell you what, we've talked about that enough, and I got lots of slides, so I'm just going to keep going. Just know that, here's a nice page that the EPA has where you can look up, all sorts of things about the whole interface between state water regulators enforcing the Clean Water Act at the same time, or parallel with, or in conjunction with, or however you want to say it, with their own state water quality statutes like Pennsylvania's Clean Streams Law. So there's a lot of interconnection here between the sort of administration of these two levels. And this is again under the Clean Water Act. Basically something is sort of falls outside it if it's either not a pollutant, it's not a point source, or the activity is expressly exempt. And that's where we get issues with the Clean Water Act, because there is this agricultural stormwater discharge exemption or definition that says it's not a point source pollutant. So again, that's the whole issue of the tension over the scope of the Clean Water Act's jurisdiction with regard to agricultural diffuse discharges. Okay, we will proceed. Now, the biosolids portion will begin now. We'll talk about the regulatory scheme. And again, this photo is nice because you can tell if you're not experienced in looking at these things along the road, let's say while you're driving, when you see this dark black stuff here, like this photo, that is biosolids. When you see something that, is more perhaps browner, and also, is less, got that real dark hue to it here and granular, then that's usually something else, food processing waste or just straight manure, something. So this, of course, look in the background, you see all the trucks coming from the sewer treatment plant here, or some type of, vendor who trades in, biosolids. And you see they're all unloading back here and they're coming in truck after truck. So that sort of gives you a little idea of what a biosolids operation looks like at a certain level. This is a certain level of activity here. Okay, so let's look at biosolids. This is a little graphic from EPA that talks about in 2023, based on data reporting, they are essentially stating that landfills are getting about 24% of the biosolids that the U.S. produces, and land application in its totality is getting about 60%. But of course, agriculture within that is attributed here as 31%. They have this other category which says home, garden, landscaping, golf course, which to me means, commercial fertilizers or biosolids being, sold in a more commercial way, rather the sort of the wholesale unpackaged way, let's just say, that goes to agriculture. So in any event, that's another form of, biosolid application, however, that certainly can cause the same problems that we're going to talk about later about PFAS. Okay, so now here is an older. While this was dated 2022, it's based on data from 2018, so it's a little bit older. And this was done by the industry itself, National Biosolids Data Project. And they have 40% attributable to agriculture, or excuse me, 40% of the biosolids produced being land applied in agricultural uses. We'll put it that way. So this is a really nice website. There's lots of different things in there, but I, again, don't want to dwell on that. Now, Pennsylvania Biosolids in that particular report has land application and agricultural purposes at 43%. As you can see, the data is not always precise. It's compiling from, an amazing, quantity. I think in here somewhere I have the number of sewer treatment facilities or wastewater treatment facilities, WWTP. If you ever see that abbreviation, that's a sewer treatment plant, wastewater treatment facilities, or I guess it's, wastewater treatment facilities, WWTP. And then landfill burial, 31%. And that's, of course, the major alternative, or incineration, is the other alternative. So you basically got three things, to do with, or put it this way, the WWPTs have three things to do with their biosolids at the end of the entire sewage treatment process. Either land apply in an agricultural setting, where it's going to be, used as a soil amendment, supplement, fertilizer, or landfill burial or incineration. Well, incineration's expensive and has tipping fees and all that, and not as, incinerators are not everywhere and available for the quantities of things that want to be incinerated, particularly because biosolids are pretty far down the chain on that. Landfills, that's one of the big issues that's going on now is that landfills are taking less or wanting to take less and less of this material because it produces methane, which then counts against them on their methane emissions. Same thing with food processing waste. Landfills are moving towards not liking this as something to take because it is increasing their methane emissions, and that's not good for them from a regulatory standpoint. And so they want to start giving the stiff arm to these things that will increase their methane emissions. Okay, here's the biosolids regulatory scheme in Pennsylvania. And this guy here in this photograph is not spreading biosolids. Apologize for that photo. That's really just either manure or could be food processing waste. I think it's probably just manure. So excuse my little photo inapplicability, perhaps. Okay. Now, the Pennsylvania scheme is all set forth on the, within what's DEP's Biosolids program, and this is a link to the website. And, basically, this is their salesmanship. The program ensures biosolids are safe for use. It sets strict quality standards and holds producers accountable. This is the reason I can't include this. Biosolids failing to meet standards must be incinerated or landfilled. So there you go, back to what I had just, and it tells you that, hey, if you have biosolids that aren't meeting the regulatory requirements, guess what? The truck's turning around and going someplace else, or the generator of the biosolids isn't leaving them at that farm. If for some reason, they're not meeting quality standards, they got to go to these other options. Okay, now DEP estimates about 400,000 tons, or dry tons, of wastewater treatment solids yearly are produced in Pennsylvania. So, nearly 500,000, or getting there anyway. At 700 municipal wastewater treatment facilities across the state. That seems a little low with all the municipalities we have, but that's the number they got. And of course, nearly 9 million residents in the state, flushing their toilets and producing this stuff. And running their drains and all of their sanitary sewer, and then of course we have all the issues of the other things that get into sanitary sewer facilities, through old outdated systems that combine rainwater, which then of course need a whole nother discussion for another day. Now, DEP's regional offices oversee this entire biosolids program. They collect biosolids samples, and that's at the outset, and I'll go through that. And they inspect the treatment facilities where it comes from, and of course they inspect the land application sites. They are the ones who police the biosolids land application program in Pennsylvania, and it's a fairly well trod path. Does not have the bumps in the road that the FPRs do. Okay. Here's some resources, just so you know what's out there. And, I gave you the link for the Biosolids program site, but there's some really good, here's the regs, of course. And the regs, this is where I should have had a site to the Clean Streams Act in here too, but because a lot of this is now clean streams, because it's not a point source discharge. It's this land application that will create some type of diffuse discharge. And most importantly, it's Solid Waste Management Act, because this is a category of solid waste, and it's what's called a residual waste, which is the result of some type of industrial process, i.e. sewer treatment or wastewater treatment, produces this thing. That's what residual wastes are. There's the regs. And then they also, of course, link to, there's a whole EPA page on biosolids, because biosolids are in fact dealt with as a pollutant, and so as we saw, and so they're involved too. And then there's a fact sheet called "Understanding Biosolids Land Application." Excellent. Very very good for like if you ever just say, "Boy, I'm just out of practice. I got to go read this." I got to go brush up real quick. That's your document. It's good. It does the job. There's a nice PowerPoint on the whole program. And then there's, some other things like the Biosolids Sampling Manual, which, defines, how sampling of biosolids is to be done for the purpose of testing what it contains and, potential pollutants and other, substances that are being looked for. PFAS is not one of them right at the present time. Unless it's especially being looked for for other purposes. It's not looked for regulatory purposes in the biosolids program. We'll talk about why that is in a bit. Now, there's a biosolids quality enhancement plan. Honestly, haven't read that one. There's guidelines for identifying, tracking, and resolving violations for the land application of biosolids. Well, as attorneys, for all of our attorneys here, there's your document right there. So that's the one that's going to help you with your clients' problems if that's where you're, while you're, in the middle of all this and needing to know. Okay, now. These are rules, this is kind of a synopsis of the basic rules. And this all came from that fact sheet. So you can get this stuff right out of the fact sheet. I don't know if I want to go over these in one by one, but basically it's a whole laundry list of the basic rules with regard to land application of biosolids, which is good stuff to know because, for example, I didn't know a lot of this stuff until I started reading up on this a few years ago. You can get through, a lot of work in the ag field without really knowing all the ins and outs. Okay, so there's some general, prohibitions like, not adversely affect a federal or Pennsylvania threatened or endangered species or a critical habitat. Okay. May not be applied to flooded and frozen snow-covered land. Yeah, okay, that's obvious. That's obviously a key factor of manure application too. May not be applied within 100 feet of a perennial stream or 33 feet of an intermittent stream, 100 feet in the edge of a sinkhole, 300 feet from an occupied dwelling, unless the owner has consented, essentially. Can't be applied in an area without an implemented ENS control plan. Within 300 feet of a water source can't be applied. And again, unless there is some sort of written waiver from the current owner consenting to that. And then 100 feet from an exceptional value wetland, so closer setback there, and then within 11 inches of the seasonal high water table, nor within 3.3 feet of the regional groundwater table. So that's the kind of stuff, and there's more. May not be applied to ag lands with slopes exceeding 25%. There's soil pH requirements. Now, here's a little more important things. Prior to the first application, the generator or applier, which is generally, somebody, either the actual sewer treatment facility or somebody who is a broker of their biosolids or of sometimes mixed biosolids from multiple facilities, if it's a broker kind of situation. But in any event, that's what the generator or the applier is, and they have to obtain representative soil analysis for the regulated pollutants for each field on which biosolids. Whoops, excuse me, did it again. On which biosolids will be land applied. So again, they have to have a baseline for the soil that you're applying it to. And then cannot be applied at a rate greater than the agronomic rate. And I believe somebody out there might tell me wrong, but I think the agronomic rate is, in other words, the take-up rate and the decomposition rate. In other words, when does it, become part of the soil? That's probably a bad way to say it. That's like a layperson's way of saying it, but that's fine. Now, may not be applied, let's see, if the maximum amount of a regulated pollutant has been applied to that area. So that's the idea of some of these things that you test at the baseline. If you have reached something that you've reached your, a maximum amount of a particular substance, then, you may be maxed out and that you're going to have to stop taking at least that, biosolids that have that substance. Now, here's the other one that's really important. The generator has this notification responsibility to notify adjacent landowners and the county conservation district at least 30 days prior to the first application. And that's all done by a notice of intent to apply. And I'll get to that in a minute. And so there's this public notice process that occurs. And that's actually the notice that DEP gets. And then we receive this notice, last bullet point here. DEP will evaluate the site, see if it's suitable. If so, they publish a notice in the PA Bulletin. They notify the local municipality. The generator can start applying after 30 days. However, if the site is not suitable, then they're going to issue some type of an order saying, no, you can't do this. So that's why you have this advance notice requirement. That's what kicks in, DEP's obligation. We'll talk about why it is like that when we get to the Solid Waste Management Act, I think, is the best place to explain that. But the bottom line is there isn't sort of like, oh, we got the approval from DEP before we ever cut a deal with, whoever the generator might be, or the generator will say, before we cut a deal with the landowner to apply there, there's not a preliminary process. It's basically you put these things in place and then you give the 30-day notice and then everything starts. And that's because there's a provision in the Solid Waste Management Act that sort of makes it have to go like that, or it's not the most ideal, but it is what it is. And DEP does a lot of these things where notice of intent. DEP does many things where notice of intent from the potential regulated party is given to DEP that they're about to start doing something, and then DEP looks at it. You can't expect them to, or them to be out there all knowing, and business entities. It's just, I'll put it this way. It's worked for DEP. Let's just put it that way. Okay, now here's the big item in terms of Pennsylvania, the actual, in addition to the regs and everything, stuff to sit there and, be reading the regs. If you're a person who works at a, for a treatment plant, or attorneys have a hard enough time reading the regs. So anyway, the bottom line is it's all translated into lots of guidelines and guidance documents, and here's one of them: guidelines for agricultural utilization of sewage sludge. And so this is a key document to everything. We've given you the basics. I'm not going to go into lots of details in there, but here's that idea of the cumulative pollutant loading rates, where you might have had a certain substance that you have reached a loading rate for, and therefore, you're kind of maxed out on that substance being brought in anymore with new sludge that might get land applied. Okay, now navigating the permits, that's another whole thing, and there are a zillion of them. That's obviously, I'm kidding, but there's many. And then there's a page called Applying for a Biosolids Permit. It's actually quite good because it's really basic, and it goes through. Here's what you got to do, and so in that sense, it's a nice page, and it's sort of separate from all the technical stuff. It's a nice, easy to read one, and here's the notice of intent concept here, and here is the notice of intent form that is to be used. Here are some general permits. We talked, we didn't talk about exceptional quality biosolids, but these are sort of like, things that may have been pre-treated, or for whatever reason they qualify, and there's a particular permit for those as exceptional quality biosolids. There are also, this looks like the more general permit, the PA General 08, and then you have 09, which is for residential septage by land application. So this is a broad page that's even talking about people who apply their own products, their own solids from their own systems on their own land. I think that applies to use of residential, maybe on others' land too. Okay, and and I guess the issue there in many ways is that's not residential septage or something that is coming from residential septage isn't going to be as processed and treated as what comes from a sewer treatment plant. Okay, more permits, more permits. There's, individual permits for people, again, who are spreading their own materials. There's a transfer if, you're taking over somebody else's operation and there already was a permit in existence. Here's the 30-day notice forms, and some of the things that, sort of are offshoots of that. Here's the actual notification of first land application, and then contractual consents when they're needed. And actually, it's needed in every case. The applier is usually the generator, the applier, or I should say the applicant is usually the generator or the applier. That way we don't get confusing terms. And so the idea that the landowner has to have a signature somewhere that, yeah, they're allowing this to happen on their property, pretty logical. And then there's all sorts of record keeping and reporting, forms and requirements. It's a constant thing. There has to be Biosolids daily operation records. There has to be Biosolids storage records for every day. This is for every single day. And now the storage, of course, it may sit for a while in some storage, but anytime it's being moved, applied, etc., it's got to, that's these things, have entries in them. Lime stabilization logs, to see if you're in fact adding lime. And then there are some technical worksheets with regard to nitrogen content, volatilization and mineralization, and residual organic nitrogen. Obviously, again, lots of technical stuff in here for engineers, but you got to sort of know, what's involved, and I've kind of run it through here. Obviously none of this is going to ever be happening without engineering expertise being applied. Okay, food processing waste and the regulatory scheme. This picture. That's the kind of thing in the new, this is the fancy new equipment that's used many times. This is like an injection type of system, I believe. It certainly has these individual nozzles down here, for application. And I think this can be used for multiple things, including food processing waste. So that's just a nice picture to show you what the equipment looks like. And again, this is, here's the FP. I'll put it this way. One of the leading cases, the Superior Court judge keeps using FPW in there. So it confuses things because most of the rest of the world says FPR. But if you just read the Solid Waste Management Act, which is the principal, statute, it, uses food processing waste. So anyway, that is that. And now here is where you really, yes, the Solid Waste Management Act is the statute, and we'll get back to it with regard to FPRs. But there's this thing called the Food Processing Residual Management Manual, which was prepared in 1994. It was revised a little bit in 2001, but it is not necessarily the most up-to-date and does not necessarily reflect let's put it that way, the way that the market and the real world is, dealing with these substances these days. And that's one of the rubs right now. This thing is so old. Look at that DEP logo that's being used there. That's how old this manual is. I don't know. I never saw that in my life until I opened this manual. In 94, I was an attorney then, but, not really dealing in these issues. And here's a definition of what, food processing waste is. Residual materials in liquid or solid form generated in the slaughtering of poultry and livestock, or in the processing, converting fish, seafood, milk, meat, eggs to food products. Also means residual materials generated in the processing, converting, or manufacture of fruits, vegetables, crops, and other commodities into marketable food items. One of the big issues that we have now is, do you want the plant or do people want to have distinctions from a regulatory standpoint between plant food processing waste and animal food processing waste? Because the animal food processing waste obviously carries with it a lot more risks and a lot more smell. Seafood, wow, that's even a whole other category of smell. And oysters and clams and things from, the coast, not far from us. This is the definition structure of the Solid Waste Management Act that tells you that these are residual wastes. Municipal waste is, sort of, it's passed through a garbage truck before it gets to, to sort of, the state, or into the state where it's regulated by the Solid Waste Management Act. Whereas residual waste is something that is produced by industrial, mining, and agricultural operations. Um, and then there's hazardous waste, but hazardous waste under the Solid Waste Management Act, just be aware, that's a whole nother category that these substances do not fit in. And even with the PFAS problems, they may very well not, they're not going to qualify yet anyway, till we have more research on PFAS. So anyway, that sort of gives you that little breakdown. Now, this is important to understand. Basically, in the simplest terms, there's a prohibition. Nobody shall store, transport, process, or dispose of residual waste of any kind without a permit. So that's basically like a landfill permit. So I'm going to use that, even though that's not the most artful way. It's, a residual waste permit would be more technically correct, but that's what landfills need. So you'd think to yourself, well, wait a minute, how are we dealing with food processing waste if it's, just if there's, if this is all these people have to be permitted just like a landfill? Well, they don't for the land application portion. Why? Because in this next section right here, it says, the provisions of this section shall not apply to agricultural waste produced in the course of normal farming operations or the use of food processing wastes in the course of normal farming operations, provided that such wastes are not classified by the board as hazardous. And food processing wastes are not. So there's that. Therein lies the whole, sort of issue, or at least the beginnings of an issue, because you have this agricultural normal farming operation that's not the same definition as used in the right to farm law. That's not the normal agricultural operation definition. This is a whole different use of a similar phrase. But there's an exemption there for the land application. See the second part of that sentence. Use of food processing wastes in the course of normal farming operations. Provided that such wastes are not classified by the board as hazardous. And the first part of the sentence, of course, deals with the agricultural waste produced in the course of farming. So neither of those things need to have the residual waste permit like a landfill would. So, and again, if I'm oversimplifying, but that gives you the stark version of why this, issue has so many, or just lots of sticky issues in here. Now, so to sum it all up, as waste, FPR is governed by the Solid Waste Management Act. It's classified as a form of residual waste, a variety produced in animal or plant food processing. FPR is commonly handled and land applied, similar to manure, and many times commingled with manure. Residential waste cannot be stored, processed, disposed of, land applied, etc., without a permit from DEP, except contains a permitting exemption for FPR land application in a normal farming operation, which is generally a soil amendment, conditioner, etc. And then there are, some conditions in there. So that's kind of the gist. Now, if you fail to have that, or let's see if I wanted to remember why. Okay. If the person fails to implement the best management practices that DEP sets forth in the normal farming operations use, if they fail to follow those things, then the department, in other words, the exemption exists, but there are still best management practices that have to be utilized in qualifying for the exemption. That's probably the best way to say it. Let me say that again. An exemption exists for land application in an agricultural operation, but you have to follow the prescribed best management practices in that, or, and here's the death knell, the department may require compliance with the land application, composting, and storage operating requirements for, and it goes on to say, basically, the residual waste permitting process. So if you flunk out of the exemption, because something isn't being done right, then you're in there, just like a landfill operator and having to do all the things they do. So that's clearly something that nobody wants to take on. So that's in my most sort of casual and flippant way. That is exactly what is being faced here for noncompliance with these best management practices. Now, the best management practices are set forth in that manual. If you're a government lawyer, you're going to start scratching your head saying, that's a little odd. Well, the statute says the department will prepare a manual. It's right in the statute, which will identify best management practices. So that's kind of the justification for that manual being, I'm not going to say the equivalent of regulations, but it has power if you fail to follow it, as this slide points out, or it has consequences, let's just say. All right. Now, there's not that much tricky about the definition of normal farming operations, so I'm going to skip it so we can talk about our hot topics. Okay, so what's the issue with biosolid application now is the PFAS contamination of the soil upon which the biosolids are being applied. This all kind of had its genesis, or I'll put it this way. This began to be recognized and become a much hotter issue after a very significant sort of blow up near Fort Worth, Texas, where several farms sued Synagro, who's one of these brokers, so to speak, of biosolids, and then you can see that the media coverage has been rampant, and it started back in 2024. And this, you look at this, it's all New York Times. This is one particular reporter on the New York Times who was like on the Biosolid beat for a while. And as you can see, it lasted, into 2025. It was just hot and heavy there for a long time. And so I'm just putting these in there so you can get some of this background. Lots of very inflammatory things being said about biosolid land application, lots of, accusations going around. And, I'm not really here to go into all of that, but the bottom line is that's what brought all this stuff to the forefront. Obviously it was bad. It was to the point where Texas County, and that's the Johnson County, which is where Fort Worth is, declares an emergency order over toxic fertilizer. Pretty, sensationalized, but they did declare an emergency order. I didn't have time to put there. I didn't have enough, I'd have been into 75, 80, 90 slides if I'd have put all that stuff. I have those things if you ever want to see it. Okay, so where do PFAS come from and how does it, where else is it? Well, it's everywhere. We all know that. We've all heard about it, and, all these different things, can produce it and put it into our essentially our wastewater system, which then puts it into our our water system, and now we're finding soils, and then it just keeps recycling back around. And here's a little chart, and there's many of these out there that sort of gives you the whole cycle of PFAS. And here it is. The treatment plant is here. They send it over here. To some type of storage facility. It's going through treatment, etc. And then here's biosolids going over to be land applied over here. And then, well, some runoff goes down and infiltrates into groundwater, and then it may be coming all back. And here's drinking water being pulled out of the groundwater, and people are using it in residential homes. And then, the process just starts all over again. So it's this constant recycling of this stuff, of this PFAS chemical, or these PFAS chemicals, because there are many, many, many of them, through these processes. And land application right here is one of the steps in that whole recycling process. Firefighting foam comes from a lot of different other things too. But it's shocking everybody, frankly, how much soil contamination seems to be showing. So EPA has a PFAS strategic roadmap that they're in the midst of, which is mostly all about trying to shut down the introduction of new PFAS into our system. Then when you have all the PFAS that has been recycling around for years, then, every time you eat something and then you have waste and then you flush the toilet and then it goes down and then it comes back around so this has been recycling for a long time. We just didn't really, sort of have a complete awareness of what was going on with all these PFAS substances. So that's all well and good, but that strategic roadmap is not dealing with what about biosolids? It doesn't deal with biosolids, and there's a reason for that. By the way, the EPA did issue guidance to states in their MPDES permit administration about best management practices to reduce PFAS discharges. But again, that was just guidance. And here's the reason that there's not a actual EPA standard with regard to PFAS in biosolids, because the Clean Water Act requires EPA to establish numeric limits and management practices to protect public health, et cetera, et cetera. Now, from the reasonably anticipated adverse effects of pollutants during the use and disposal of biosolids. Okay, statutory duty. But it also requires them to review its biosolids regulations at least every 2 years to identify additional toxic pollutants. So how are you going to know about the existence of these toxic pollutants, or whether they're toxic at all, unless you have some type of a process for recognizing new ones? And that's kind of where we are right now. So EPA is doing this review, and they've acknowledged, okay, we have PFAS in biosolids, and then it says, and then promulgate regulations for those pollutants if sufficient scientific evidence shows they may adversely affect public health or the environment. EPA has not yet established numeric limits or monitoring or reporting requirements for PFAS in biosolids because they haven't completed this process yet, and they're still in the middle of it. This is a little schematic that shows you, a little flow chart that shows you what was on that previous page, this risk assessment. In other words, okay, it's EPA is past the point of identifying PFAS as a component that appears in biosolids. Now it's the risk assessment portion down here, and either does it exceeds EPA's level of concerns? No. Then actually it should be yes, shouldn't it? Okay, yes. Exclude the pollutant, meaning don't write any regs on it, or yes, consider writing regs on it. Well, that's where we're at. The assessment came out January 15th of 2025, and this is the document. You can get it here by clicking on all these links. And so this was EPA's assessment, and this is sort of the definition. I'm going to go quickly so I can get to the next issue. And then, will there be further effort to be taken by EPA? Well, this is my sign for crickets, because it does not seem likely that the current administration is going to do anything to follow up on that risk assessment, which, in fact, found that EPA finds that the draft risk estimates exceed the agency's acceptable human health risk thresholds for some pasture farm, food crop farm, and reclamation scenarios. And they find that it may be a human health risk associated with drinking contaminated groundwater sourced near a surface disposal site of biosolids when sewage sludge containing, and then there's a little standard here that is in their assessment. So, 1 part per billion of PFOA, that's the one substance, and 4 to 5 parts per billion of PFOS. So that's where we're at right now. It doesn't seem like the current administration is going to move this thing. It's not on the regulatory agenda to do regulations on PFAS and biosolids. So it's become a state, and here's an article I wrote that appears in a couple different places. The 2026 regulatory agenda for this administration's EPA is not out yet. It'll be out after the turn of the year. We'll see if this appears on there. I suspect it won't. So now we're into this whole state-by-state thing where individual states are going to start to regulate PFAS in biosolids on their own without any sort of overriding thresholds, et cetera, set by the EPA, which means that we'll have a patchwork system of different standards and different things all over the country, which we do have right now. This is a link to a compilation of them that was done by an engineering firm that's technically based in Philadelphia. And so go see that if you want to see what various states are doing. Okay, now food processing residuals. What's up with that? Well, it's basically the Pennsylvania scheme is outdated. Why? Well, we'll get to that in a second. You've probably seen some of these, headlines around in the mid-state area. This was particularly in 2024, a whole bunch of, articles appearing, lots of things, inflammatory things being said. This one was just flat out wrong. This was something Echo Pilot, which I forget if that's Chambersburg, maybe. Food processing residual isn't regulated in Pennsylvania. Wrong. Some people think it should be. Well, yes, and it is. But, of course, the odors are the thing that, is really causing the issues. Okay, now what are the contributing factors? Well, this transportation or I should say, the contributing factors to why we have this perceived need to have reform. Transportation and brokering of FPRs is not regulated in the same manner as manure. So there's no equivalent of the Manure Hauler or Broker Certification Act. So these people that are driving FPRs around and to places no one has any real strings on them if they're independent contractors and they're not the generator. So here is one of the problems. Some of the articles that produced these complaints and got people pretty stirred up had to do with accidents where this stuff was being dumped on a road accidentally, and then who's this truck? Well, where are they coming from? We don't know. DEP wouldn't even have identities of who these people are that are carrying this stuff, and making it worse, it might have come from out of state. So, they don't even know where it came from. So clearly they don't know what's in it. So, that's a problem. The system envisions that, the generator will be located in Pennsylvania, and then, meaning the sewer treatment facility or the broker who buys it from them and delivers it to a farm will be located in and they process it in the middle there, will be located in Pennsylvania, and there'll be some type of regulatory jurisdiction over them. Well, the market has changed. That's not what's going on. This stuff is crossing state lines now. So trucks can have an accident in Cumberland County, and we don't know who they are, where they came from, what they were carrying, what's in what they're carrying, and where they're going. Or DP doesn't know that. This idea of coming up from the southern states seems to be, an idea, particularly when it was, I think somebody called them clam bellies. Well, I don't think there's anybody processing clams in Pennsylvania. So now I could be wrong. Maybe there's seafood processors who have that as a food processing waste. But in any event, now the manual treats the land application as a last resort. Now it is the predominant method of disposal because landfills, well, maybe not accepting, but are reluctant, and it's costing more to dispose at landfills. So the manual doesn't really quite treat land application as the primary method, but as we saw from some of those numbers, it's getting to be the primary method, if not already overshadowing landfills or incineration. From a who's got the highest percentage of use. So newer and variable business models not accounted for in the manual. That means the out-of-state stuff. Practices have changed, volume has greatly increased, and then again, that includes the out-of-state stuff, I should say. Here's the one that I mentioned before. FPR crossing state lines into Pennsylvania frustrates the regulatory scheme in multiple ways, and it introduces new forms of FPR, i.e. clam bellies or other things, that we haven't seen before. Smells can be worse. Land application system plan is the thing that the food processing waste manual sort of relies on, but the provisions may not be adequate for today's world and for the public expectation of what we need to know about these substances at this point in time. And then, there's inadequate documentation requirements for what's in the FPRs. And then, commingling them with manure. This is a whole nother issue, which is, if if this food processing waste is just being dumped into a manure pit, and then its decomposition and breakdown process and all the things that this manual is based on, it's not necessarily scientifically aligned with the idea that this food processing waste would be just dumped into a manure pit, and then it's being treated but like manure, and the nutrient management plans end up becoming a mixture, or the things that are being done to a mixture of manure and food processing wastes. And just from a scientific standpoint, that's not really apples and apples. So, that's another sort of at the farm problem. In in a regulatory world where everything is neatly siloed and separated, you would never store food processing waste with manure because it's biologically different. But it is being done. So that's a whole nother issue too. So having said that, there was an FPR workgroup established in 2023. I was on that. There's a report. There's a link for the report that was issued. Now it's all over. It was a year plus ago, a year and a half ago. Yeah, pretty a year and a half. And it's getting old. There have been responses to this work group report, and there has been legislation introduced. But again, I'm not going to talk about that because we don't know where it's all going to go. But the basic concept with that is that there'll be hopefully a food processing waste broker and hauler certification. First of all, to parallel the manure, hauling type of strings that get attached, so you can track things when there's accidents and know what things are and where they're going, et cetera, and who's carrying them and all that sort of thing. So as soon as you get across the state line, you have to be licensed by PA to carry this stuff. And you got to have paperwork on you that says where it came from and what it is and what the chemical composition is and where it's going to, all those things. So here's a number of other, and then other recommendations. Other parts of this are amending the Solid Waste Management Act and updating this manual. So all those things, there's a whole ball of things that need to be worked on, and there are people who are trying to work on them, but this has been very slow. All right, having endured my last hour of an ABDC webinar, I have one next Tuesday that's in connection with the AgWorks, but that is my very, very last one. So I'm thankful for everyone who attended, and thank you so much for paying attention to my, not necessarily always systematic and insightful words. But I'm thankful that we have such good attendance for these webinars. It's been a great pleasure, and I've loved working here at the Ag Law Center, and loved working in state government for all the years that I did. Loved working with the people that I met and worked with there, and including everybody at the legislature and Miss Golden, who was in attendance today. So thanks to everybody, and I am going to go ahead and sign off.